Okay, Keith, how are you doing today?
Doing good. How are you?
Good, good. Hey, so several members of the jury pool, eagle eyes, they picked up on something, and I think I want to talk about it today because I'm now confused about how the court is going to move forward when we're dealing with Blake Lively's potential emotional distress claims or damages that flow from that. And so I wanted to throw up real quickly the court's order that we looked at, you described the other day. Let me see if I can pull that up here. And you can see it's really just the last sentence here. But if you recall, Blake Lively was going to have to answer some discovery where she was going to have to give like her psychiatric records or psychology notes or whatever it is in response to two claims that she had brought. One was for intentional infliction of emotional distress and negligent infliction of emotional distress.
Yeah.
And so in order to keep from having to turn over her therapist notes and psychiatric records, if there are any, or medical records, just generally speaking, she says to Baldoni's team, well, don't worry, I'm just going to withdraw those two claims. And they were claims 10 and 11 or something like that. She has 10 or 11 causes of action.
13 total, I think.
13 total. Yeah. Okay. So she's going to withdraw two of those claims. And the question really between the two sides was whether that withdrawal would be with prejudice or without prejudice. And some people had even asked about that. Could you tell us the distinction between withdrawing something with prejudice and without prejudice?
Yeah. So if you withdraw something without prejudice, that means you can refile it. So it's as if you never filed it in the first place. It's a do-over. So you can refile in the future. You might be stopped by a statute of limitations, but it's as if you didn't file it. When you withdraw or dismiss with prejudice, it's as if you lost. It's like you went to trial and lost. You're closed from ever filing it again. It's a done deal. So that's why with prejudice is a bigger deal, and that's why Baldoni would want it. We want you to withdraw these claims with prejudice, meaning you're forever barred from filing them ever again.
So there was a tit for tat going on there. The idea was, we're Blake Lively's, we're going to withdraw, but it's going to be without prejudice, which leaves the issue lingering at least until the statute of limitations runs. And Baldoni's team is saying, no, you got to do it with prejudice because we don't want to see this again. We don't want to deal with these claims again because we're going to be right back here fighting whether we have a right to your medical records, your therapist records, and whatever else flow from that. And so the judge says, look, I'm not having any of this. You guys are, fighting, like you said, two kids in a sandbox over a toy.
Yeah.
And so you guys go figure it out. Denying the motions, you go figure it out. And if you can't figure it out, then Lively can file whatever motion she thinks she needs to, right?
Yeah.
But then the court said, however, and this is what the jury pool picked up on, several members in the jury pool, for avoidance of doubt, if the claims are not dismissed, the court will preclude Lively from offering any evidence of emotional distress.
Right. So what exactly does that mean? What comments did you see that kind of raised this issue in your mind?
So many people said, okay, look, you take the negligent infliction of emotional distress and the intentional claim. You take both the negligent and intentional claims and you toss them out like Lively's withdrawing those, they're gone. If you read the rest and the balance of her complaint, just in about every cause of action, sexual harassment being the primary claim, she claims that she was emotionally impacted, that she was harmed emotionally. And so what do we do with that? Well, you and I are lawyers and we're sitting here, we're saying, well, these things get withdrawn from time to time, but you normally don't have a judge basically saying whether it's withdrawn or not withdrawn. Let me tell you what, I'm precluding Lively's team from offering any evidence of emotional distress. And then my question is, what does that mean? Does that mean it only applies to the two claims?
Causes of action that were withdrawn?
Correct. Or not withdrawn if they're just sitting there. Or does it apply to the whole case? In other words, what Baldoni's lawyers, if I was Baldoni's lawyers, I would say, look, this applies to the whole case. And if you want to talk about emotions on any level, even for a second, in continuing your sexual harassment claim, you are precluded from raising any of that emotional damage evidence because the judge just said you can't offer any evidence of emotional distress. So was the judge focusing just on those two causes of action, or is the court saying as a blanket here, because you're not turning over your medical records and your therapist notes and all these other things, you're precluded from raising emotions in the entire case?
So this comes down to the issue of we need to understand what damages are available to a plaintiff in sexual harassment cases. And we also need to talk about what's termed non-economic damages, because that's going to make a difference. Now, I do want to just point out that intentional infliction of emotional distress, it's a cause of action where you sue somebody for outrageous conduct that shocks the conscious. So it's quite a bit different from a sexual harassment claim. I mean, it can be similar to a sexual harassment claim or sexual assault, but it can also be very different. But now you're saying that the emotional distress portion of this, maybe that does apply to other emotional aspects of the sexual harassment case. So what are we looking at here?
So what we did is we pulled up the CACI jury instructions, and these are jury instructions that have not been fought over by the parties yet. But something similar to this will be used at the time of trial, where the jury is going to be read jury instructions by the judge. The judge is trying to educate the jury on the law, how it works, and how they're to apply the law to the facts and so forth.
Are jury instructions used in every case?
Every jury trial that I'm aware of, and there's form jury instructions, and courts like those because those have been created over time, and they're good. They're solid. They've been thought through. You can also request special jury instructions to be given to the jury. That's more problematic because you got to convince the trial judge to give you a special jury instruction. Usually you pull that from case law or a statute or something that's very beneficial to you. The problem with that is you really increase your chances of getting overturned on appeal when you use a special jury instruction. So generally you want to try to use the form jury instructions. And here in California, we have the CACI jury instructions.
And this is actual instructions that a judge would read to a jury and instruct them on what their job is after they heard the evidence.
So there's a big fight initially in a case when before you even start picking the jury, there's a big fight over what jury instructions you want the judge to read to the jury and what the defense wants the judge to read to the jury. And then ultimately the judge will make a decision and there'll be a list of jury instructions. And believe me, the jurors, they literally want to stab their eyes out during jury instructions because the judge sits there and reads them, and it's hours sometimes of jury instructions.
Depending on the number of claims and all that.
Correct.
But the thing that's so interesting about looking at the jury instructions is this is exactly, or something very similar to this. I mean, this is California jury instructions and they're in federal court. But it's going to be something very similar to this that will be read to the jury, and the jury is going to be told, these are the instructions you have to follow in making your decision.
That's right. And so damages would come much later in the jury instructions. Generally, a court will introduce everybody.
Liability first.
Well, just introduce you to the court system and how juries work. There's a whole series of jury instructions just to kind of give people to ease into the process. Right. But ultimately, damages are looked at. But I think it's important to look at, and we're getting into a little bit higher level learning here, but I think if everybody hangs on, they can do it. There's economic and non-economic damages.
Okay.
And so what's in your mind, Keith, if you were to say that in layman's terms, what is the distinction between economic and non-economic damages?
So economic damages is the money that you're out. So it's money that you should have had that you lost. Maybe you missed out on time at work, or you have doctor's appointments that you had to pay for, things that are literally money out of your pocket. Non-economic damages are things that you can't they're not necessarily money out of your pocket, but there's still harm that you suffered beyond the economics. So a very common example is pain and suffering. That's a typical non-economic damages.
So you talk about breaking my jaw. You punch me in the face and break my jaw. So that's a battery. And I sue you for that. And I sue you for the pain that I had to recover from this, the surgery on my jaw, and just the fact that it was broken. That's painful. And the recovery process, I missed, and I also missed work, and I had to go to doctor's appointments and pay doctors that I normally wouldn't have to pay. So the non-economic damages would be the pain and suffering that I went through because you broke my jaw. And the economic damages would be the receipts that I could show for the doctor's bills, for the fuel to get to the doctor, for whatever else I had to pay for with a receipt. That would be more like in line with economic damages.
Yeah. And then there's also, if I punch you in the face, you get pain and suffering, but you also get just general damages, which is a damage that's meant to make up for the fact that in our society, people shouldn't be punching other people in the face. And so the jury's allowed to award an amount of damage for the fact that happened to you.
Right.
And so there's all these different levels of damages, and they all add up. So you'll get the economic, you get the pain and suffering, you get the general, and then you add all those amounts up, and that's your total jury award.
So here's just the quick instruction from the CACI instructions. And it says the damages claimed by whoever the plaintiff is. It's going to be Blake Lively, or if it's the defamation claim, it'll be Justin Baldoni. The damages claimed by for the harm caused by whoever the defendant is fall into two categories called economic damages and non-economic damages. You will be asked on the verdict form to state the two categories of damages separately. So just the court wants to introduce people to the idea that there are these two, there's different kinds of damages, but generally speaking, there's going to be economic and non-economic, right?
Yeah.
Okay. So let's take a look at what you actually have to prove in this case. And this would be, again, this may not be exactly how this ends up happening in this case because these jury instructions are fought over. But here is the jury instruction for work environment harassment, which is a hostile work environment. And it's directed here at the employer or the entity. There's also one that's directed at an individual, but we're not going to take the time to go through that. They're very similar. There's a little change in the individual one. But walk us through, the judge is reading this to the jury. What is the judge reading to the jury about this particular hostile work environment claim?
So this is the instruction that to establish this claim, and here I'm going to use plaintiff, which in the sexual harassment case is going to be Blake Lively. So Blake Lively must prove all the following. Number one, that Blake Lively was an employee of an applicant for a position with or a person providing services under a contract with an unpaid intern of defendant. So in other words, there had to have been some sort of relationship between Lively and, Wayfair and the Wayfair parties. Number two, that Lively was subjected to harassing conduct because
she was a woman.
Yeah, she was, and then protected class woman. So that's the second thing that the jury would have to find based on the evidence. The third thing the jury would have to find that the harassing conduct was severe or pervasive. Okay. The fourth thing is that a reasonable woman in lively circumstances would have considered the work environment to be hostile, intimidating, offensive, oppressive, or abusive. So that's the objective person standard. So somebody else in the same position would have felt that the environment was hostile, intimidating, offensive, oppressive, or abusive. And then that Lively considered the work environment to be hostile, intimidating, offensive, oppressive, or abusive. So that's where Lively herself has to consider it. The one before, number four, an objective person also has to consider it to be hostile.
So there's an objective test and a subjective test.
Right.
Okay.
And then you have to, number six, select applicable basis of defendant's liability, that they're a superior engaged in the conduct, or in other words, like who, was it a supervisor? Was it an employee? And then number seven, that Lively was harmed. And number eight, that the conduct was a substantial factor in causing Lively's harm. So these are the factors, the 8 factors that the jury would have to consider and would have to decide in Lively's favor for Lively to win a sexual harassment claim.
So the judge will actually read this to the jury. Yes. And give them their charging orders as they go back to deliberate. And then the jury will be given a verdict form. And this is the verdict form that they'll be given. And again, it'll be a little bit different than this, but I think it's
very similar.
I think it's important to walk through this. So I like how California does this too, because you essentially have to say yes in order to move on
to the next question
from each question. And if you say no to any question, the case is over.
You stop.
That's it. So walk us through this. So as the jury is doing this, that gets to number 1, and it says, was Blake Lively an employee or a volunteer, or was she under a contract, or did she somehow work for the defendant?
Okay.
And so you're going to and when we argue this in front of a jury, we literally blow this up on a board if the court allows us. Most courts do. Federal courts, not so much. And we literally take a red pen out and we check the ones we want the jury to check, right?
Right.
So here it would be, let's just assume that you check yes. And so then what would we do then as a jury?
Then you go on to question number 2. And it says right there, if you check yes, go on. And if you don't, stop here. So number 2, was Lively subjected to harassing conduct because
she was a woman?
Because she was a woman. Okay. So that would have to be a yes or a no. And so the jury would have to decide whether that's true or not.
Okay. And so then let's assume that the jury says yes on that. I'm just going to assume that they say yes.
Then number 3, was the harassment severe or pervasive?
And this is what's tough about jury instructions, because the jury has been read by the court what's severe and pervasive means, 5 hours ago.
Yeah.
Or 2 days ago.
Right.
And you get to this one, and what does that even mean? What does the was the harassment severe or pervasive? What does that mean? I mean, how do we how do we get through that as a jury? And you can't go and ask the judge to come back to you in the jury deliberating rooms and explain everything to you. The judge is going to tell you, I've read the instructions to you.
Follow the instructions.
Follow the instructions. So you have to answer a yes or a no here. And I think the jurors get it, that if they answer no here to this particularly hard analysis right here, the case is over as far as this particular cause of action goes.
Right. Yeah. So if a jury looked at this and said, we don't feel like this was severe or pervasive, no, boom, done.
Right. And so you can see how hard this, but let's assume that the jury somehow, some way says, yeah, I think it was severe or pervasive, and they mark yes. What's the next one?
Would a reasonable woman in lively circumstances have considered the work environment to be hostile, intimidating, offensive, oppressive, or abusive? So again, this is that objective person. So not looking at liability, but looking at a reasonable woman in the same situation. Would that woman consider this to be hostile or offensive?
And then number 5. So let's say they say, yeah, I think an objective person would find this. Now, again, they have to look at the facts, and then they get to determine the facts. And then let's say the jury is persuaded by that, then they would move on. And if they weren't persuaded by it, they'd select no, and the case would be over. But if they did select yes.
Then did Lively consider the work environment to be hostile, intimidating, offensive, oppressive, or abusive?
And that's interesting because not only do you have to meet the objective person test here, and that is the reasonably prudent person, would a reasonable person feel this was a hostile work environment? You still have to say, okay, a reasonable person would, but did this person individually, did they feel this? So you're asking that question in 2 different ways.
So in other words, you don't want somebody who is just easily insulted. You want this to be, okay, she felt this way, but an objective person felt that way too. I think we're on number 6. So
I have a quick question.
Yeah.
And you might have gone over this. I might have missed it. But so does every person in the jury get this sheet, or is it like one combined and it's a collective answer?
That's interesting. I don't know the answer to that question. But let's assume that everybody has the sheet in front of them to play with.
Yeah.
Or it might just be the foreperson with a sheet, and they're going through talking about this. But let's just assume that everybody has it.
Yeah.
What I thought you were going to ask is, what if on number 1 out of 12 jurors, and this is not a federal court, it's a California case. I mean, it's a California case. I'm not talking about federal court. You only need 9 of 12 in California juries. And you get 9 of 12 to answer yes to number 1.
Mm-hmm.
What if on number 2, you get 9 of 12 again, but it's a different 9 of 12? Can you keep going on? What do you think, Eric?
I would think yes.
Yes, you do. And that's something you have to explain to the jury. And it does happen from time to time where you're going to get a different 9 people to agree that number 2, and you're going to get a different 9 people to agree that number 3. Mm-hmm. But since this is a federal court case, I think you're going to need unanimous findings here. And so then you're going to need, everybody to agree as you go forward, which makes it even more difficult.
Yeah. This was a question too, which sparked my question. Do all jurors have to agree to move on to the next question? What happens when they disagree? So you kind of got to that there.
Yes. Yeah. In California, you would need 9 of 12.
And then you can move on.
You can move on. And then you can get a different, it can be the same 9 all the way through, but sometimes you get to a question where one of the 9 that said yes to the previous 3 says, I just don't like this one. I can't agree with it. But then you get somebody else to go, I can go with that.
Yeah.
So,
but if it's unanimous, then you have to work. And this is a group project. I mean, the juries have to do this as a group. Even if they have individual forms, ultimately it turns into a group project. So number 6 I guess that'd be the Wayfair parties.
Yep.
Know or should have known of the harassing conduct.
Yep. And
number 7.
Well, so you would answer yes or no there.
Yes or no.
Okay. If you answer yes.
A little bit of a reading test, like eyesight test for me.
Yeah.
And then did Wayfair parties
fail to take immediate
and appropriate action to remedy the situation, I suppose. So, and that would also be a yes or no.
And so then we get to, look at this. Look at how much you're going to have to prove to get to the point where you've, so you had to answer yes or no to 7, and then you get to number 8.
Then was the harassing conduct a substantial factor in causing harm to Lively?
Okay.
So whatever harm you're saying you suffered, all of the things that we just talked about, that has to be a substantial factor in causing that harm.
And nobody knows what a substantial factor is.
Right.
Okay, there is a jury instruction on it, but it's clear as mud. And so you have to explain to the jury in closing and in voir dire, when you start the case, that you're going to be talking about some terms in the case, and you want to go over those things. And so substantial factor, there is a way to describe it and explain it. I won't bore everybody with the details, but you can explain it the best you can for the case that you're arguing, whether it's a personal injury case, sexual harassment, whatever.
Yeah.
But let's say that you've convinced the jury. So far, you've gotten them to say yes 7 times. They haven't said no 1 time. Now they get to get all the way to number 8. And let's say they say, yeah, we think it was a substantial factor, whatever they think substantial factor means.
Now let's get the damages.
Okay.
Can you highlight just the damage section?
I can, yes.
Because this is really where it's at for our discussion today when we're talking about the emotional distress. So here you have it. So 9A, past economic loss.
So remember, Keith, we have 2 kinds of damages. What are they?
So there's economic and non-economic.
Okay.
And A and B are going to be economic. C and D down there are going to be non-economic. So what are the past economic losses? Well, things like lost earnings, lost profit, medical expenses, other past economic loss. So what has Lively lost in terms of earnings from whatever this sexual harassment conduct was for past earnings?
And we know she's not going to get medical expenses because she's not producing any medical records.
Right.
So that special damage is gone.
And I don't know that she lost any earnings or profits because she still got paid for the movie.
Okay. So and then we're talking about past economic losses there.
So now we have future economic losses.
And so that would be, well, what was her trajectory in Hollywood before this?
Right.
And that's debatable. So you have to hire experts to come in. You're going to get an economic expert on the plaintiff side, probably several of them, and you'll get an economic expert on the defense side, and they'll both offset each other. But this is going to be very expensive and time consuming to have these 2 experts opine on how much Blake Lively, number one, was she an A-lister or was she not an A-lister? How much did she command for movies going forward? How much has that been impacted by the fact that she came forward and said, hey, I've been sexually harassed and I have to move forward on this? So is there a damage component that you can put down there?
There potentially, I suppose, if the jury were to get this far, a jury could determine, I guess, based on experts that, we think that she lost 3 movie deals. But it's also true that if a jury got this far, they could say, it's hard to see what she lost on future economic loss because she is a big movie star. Another movie came out right after It Ends With Us. It seems like she has other movie deals going on. So what is really the lost earnings? This is a little easier to calculate on like a person has a normal job where they're making, $100,000 a year, and then this happened and they lose their job and now they're on unemployment, and you can say, hey, I was going to make $100,000 a year for the next, 20 years. It's a little bit easier to zero in on that. But with Lively, it's like, what has she lost? And is she really not getting movies now because of this? I don't know. They're going to bring somebody in. Certainly there's a paid expert out there somewhere who's going to come in and say, oh yeah, she's lost 3 movie deals, because you can always find an expert witness to say something.
But there'll also be an expert on Baldoni's side that will come in, and they'll also get to weigh in for the jury and say how there is not a loss.
Right.
Not only did she not lose anything in the past, she's not lost anything in the future.
Right.
And so then it'll be up to the jury to determine which expert is more credible. Is it Blake Lively's expert or is it Baldoni and team's expert?
So now let's go to the non-economic loss and look at how you have physical pain and mental suffering. And then we have future, so that's past, and then future non-economic loss, including physical pain / mental suffering.
Right.
So now the question becomes, okay, well, what mental suffering can she prove if she's precluded from offering any evidence of emotional distress? And I suppose on the one hand, I'm thinking, okay, you can't bring in your medical records because you refuse to produce them. You can't bring in therapy records. Could she just testify? Hey, just take, I'm going to testify. She has the right to testify. That is evidence. It may not be the strongest evidence, but it's evidence. And she can say, oh, it was terrible for me. I suffered. And then she can bring in her husband and said, oh, I'm her husband. I lived with her and I could see she was suffering. Is that sufficient to get non-economic loss of, mental damages?
It can be, but maybe not in this case.
Right.
And it can be because typically you've got garden variety emotional distress. That's not the negligent infliction of emotional distress or intentional infliction, which those are big, grandiose ideas. There's a diagnosis. You're seeing doctors. You're depressed. There's medical records. There's notes that people can look at. And we can see from the baseline before this that you were a normal person. And now you're not a normal person because of what you went through. You have PTSD. There's all kinds of things that come with those claims. But because Blake Lively had to withdraw these claims and the way that she's doing it, and because there were several sharp-eyed people in the jury pool saying, but wait a minute, she's got all kinds of claims for emotional distress throughout her complaint. And here the judge is saying that the court is precluding her from offering any evidence of emotional distress. And again, it comes back to, does the court mean this in relation to those two claims only? And in that case, I agree with you. You can do the garden variety thing where Ryan Reynolds can be called and say, oh, yes, this was very hard on Blake. You have other people that can be called and say, her personality changed and she's been very down about this and she doesn't want to work anymore, or whatever it is that they would testify to. That I don't think would give Baldoni and his team the right to get her medical records and her psychiatric records, because that's just garden variety.
But it also isn't very strong evidence.
Not very strong evidence either. That's correct.
It's better to have a diagnosis. And I mean, if you really were suffering emotional distress or any type of mental harm, I guess the question would be, why didn't you seek help? And, you would go to therapy or whatever it is you would do. So it's not the strongest evidence either. And so, I guess the question is, when the judge said Lively is precluded from offering any evidence of emotional distress, that could potentially really hurt her on the non-economic damages portion of this.
So I would push this. If I was Baldoni's attorneys, I would push this further. I would file something to say, hey, we still need to get her medical records, because she's still claiming in her sexual harassment cause of action and this cause of action and that cause of action. Yeah. She's still claiming that she was damaged emotionally. And, it'll give the court the ability to either clarify what he meant when he said, I'm not going to allow you to bring any of this evidence forward. And he can say, well, I meant that only as to these two causes of action. Or he can say, no, if you're not going to give your medical records, psychiatric records, which that's a big deal, having to give those up. Yeah. And I know there's an attorney's eyes only issue here. Some people pointed that out as well. And I thought that was astute as well. You got the attorney's eyes only issue for medical records. So does that protect Blake Lively to some degree here? Or is that still something she still doesn't want her medical records to come up?
Well, she clearly must still have a problem with it, because otherwise she would have produced them and not withdrawn those claims. So I'm assuming that the answer is she doesn't want to show anybody, even under attorney's eyes only, that type of information. So,
and Keith, do you think that envision there had to be a meeting of some kind between Blake Lively's lawyers and herself to discuss this issue, right?
You would think.
Well, you don't withdraw claims without talking to a client.
Of course not.
Okay, so there would have to be a discussion.
There would have to be, yes.
So they would have to explain to her, look, this could really gut your case.
And it could hurt your damages. And so, you can testify that, I was suffering mentally, but boy, that's not very strong evidence, especially when it's a party. They have something to gain by testifying that way, versus medical records from a care provider, even though it's your care provider, but it's still an independent person who's providing care and doing diagnoses and whatever. I think it's just stronger evidence all around.
Yeah. So, well, I still think we need to find out. And again, kudos to the eagle-eyed individuals who pointed this out. And that is that there is quite a bit of evidence, or at least claims, of emotional distress throughout the entire complaint. And so, whether she can use that as evidence going forward or not, it's a question that needs to be resolved.
Well, and I'm really happy that we were able to pull up the jury instructions and the verdict form, because I think those are documents that a lot of people who especially aren't lawyers have never really experienced before. And it does kind of summarize exactly what the jury would be told. And those aren't the exact instructions, but it's somewhere along the lines. And it also shows you the verdict form, what the jury actually has to wrestle with and fill out in order to make a decision. So, I mean, hopefully that was some good insight for everybody, because I found it very interesting.
The one thing that I think would be also interesting to do, and we'll ask the jury pool on this, is would it be good for us to run through the defamation claim of Justin Baldoni and use the jury instructions for that? I think they're less complicated. I have not looked at them in a while. But I think for defamation claim, you have to prove less. There's not like 9 things you have to go through. So if that would be helpful next week or whenever we get a chance, we can run through the same things that he's going to have to prove. And in light of the evidence that we've seen in this case thus far.
Yeah, I think it really puts everything in context. Like, this is ultimately what they're fighting about or what they're aiming for. And it also helps the lawyers. It's like anytime we're coming up with a discovery plan, often we do look at the jury instructions because that's the end point, right? That's where you're going to arrive at. So if you're going out hunting for evidence, you have to think about where you want to end and work backwards from there, and then figure out, well, what evidence do I need to meet each of these elements that the jury is going to be told about? So, I promise you that both sides are very familiar with the jury instructions and have probably reviewed them in this case in formulating their discovery plans.
It's interesting because we do a lot of financial elder abuse litigation, which gives us a right to a jury trial. And the first element that you have to prove to a jury to win that claim in front of a jury is, number one, that the person was 65 years of age or older at the time that the alleged abuse took place.
Yeah.
And so what we do is we send out requests for admissions to the other side, and we say, admit the person was over 65 years of age on 2018 or 2019 or 2020, whatever the year is, whenever we think that alleged abuse took place. And once they admit that the person was 65 years or older, you don't even have to ask the jury. I mean, you have to ask the jury, but you can say they've admitted that the person was 65. So you can just mark yes there. You don't even have to consider that. They've conceded that point. And then you go on to point number two. So you bring up a good point. When I was a young lawyer, I remember I went to a CLE, and one of the older, wiser lawyers was there and said, you got to get into the jury instructions when you're drafting complaints, when you're doing discovery, when you're doing depositions, because it gives you the roadmap of what you need to prove in front of a jury.
It's a little counterintuitive because you're thinking jury instructions, that comes at the end. No, that's true. But that's the point where you want to arrive. That's telling you your destination. So it helps you plan it out.
I agree. I think that was really valuable. I mean, I've never even had to do jury duty. I mean, watch me get a thing in the mail next week, but jinx myself. But yeah, I thought that was pretty valuable. And people are saying you should do the defamation side. Maybe next week or whenever we get around to it. Here's another, just kind of because all these nuggets might make it back into the trial. And Virginia, this is a good observation, says if you can make jokes based on your wife's alleged sexual harassment through the nice pool characters and the SNL jokes, there is no emotional distress or harm.
That goes to our point, I think, of,
Right.
Think about what you want to show the jury and the evidence. And that's one piece of evidence that obviously Friedman would want to show the jury in order to make that argument.
Yeah, you're making light of a situation, and why are you doing that? If your wife is so triggered by that, by the way, she's sitting right down there looking up at you while you're saying this.
Right.
So, she looks fine to me. How hard could this have possibly been for her?
Well, we mentioned that at the time that Saturday Night Live skit, that's going to be, playing in the courtroom, I think.
Yeah.
So
It is, you think?
Oh, yeah. I think,
Okay.
yeah. Well, I mean, again, a judge can always keep evidence out if they think it's going to be, if they think it's just not worthy of bringing in, it's going to cause confusion for the jury and it's just going to cause a mess. The judge won't allow it in. But I would say, if I was the judge, I would certainly let something like that in because it shows how she's acting after the fact.
Right. Yeah.
What about this question? Can jurors take notes with pen and paper?
Yes, they can. Again, up to the judge, but yes, most judges are going to allow that, but you don't get to keep the notes. The notes will stay with the court when you're done. Most likely they'll be destroyed. But yes, you can take notes, and it's good. I liked it when jurors take notes. In fact, I'll speak slower at times when I see jurors are taking notes. I want to make sure that they're getting this, and so you slow down a little bit and you walk them through it a little bit slower.
I thought this was interesting. This is back to our case one and case two. They're all baked in together. Can the outcome of case one be used as evidence for case two?
Well, yeah, possibly. And so if there is case one being the sexual harassment case, there could be evidence in there that would be helpful for case two being the defamation claim back against Blake Lively, especially if there's just no evidence of sexual harassment, or the jury's not convinced that there was anything here that they find to meet those 8 items of sexual harassment. So it's certainly possible.
There it is again.
Yeah, and my guess is that it's going to be one jury hearing all of this.
Right.
I could be wrong. They could bifurcate the trial, but it's going to be, so they're going to know what they want to do in the jury deliberation room. And so if they are convinced of, Blake Lively losing or winning, they'll know that, and that kind of will dictate where they're going with the defamation claim, I would think. Juries do things, Keith, you and I have paid for juries to make arguments where we get to stand behind a glass wall that they see as a mirror and we can see through it. And it's interesting what jurors talk about, that they generally do get to the right result, but you have to arm your jurors. We've talked about this in the past.
Yeah.
When you start a case, I've always figured you've got 6 jurors on your side and you got 6 jurors that don't like you. Sometimes I had an attorney that I went against in the past that said, sometimes jurors just don't like your shoes.
Right.
But you got 6 against you and 6 for you. That means in California, you only need to get 3 that are against you, right? Because you need 9 total. Yeah. So what you have to do is you have to arm the 6 jurors that are favorable to your case. You don't know which 6 jurors they are, so you arm all the jury. And so you're constantly arming them. And what we found is if we do these mock juries where we get to watch the jury argue behind this mirror, we find the weaknesses in our presentation and where we weren't clear, and the words that we thought were just going to blow the case wide open, and the jury's not resonating with that, but we hear what the words they're using, and then we find that once we arm those 6 jurors, they feel so much more confident when it's a new set of people that go back the second time, but you can see the people that are our 6. They are actually arguing and advocating for our position because they've been armed properly. And so our hope is those 6 that are on our side are going to be able to get 3 to come across with them.
Yeah, that's right. Yeah. Just to be clear, we've never paid juries, but we have paid for mock juries.
Yeah, which is ethical and legal.
Ethical.
Yes, right. That's correct.
But it is interesting how the whole case will be presented in front of a jury if the defamation claim survives and goes to trial. And that jury is ultimately going to make a decision and get a kind of a feel for the way that they want the case to go. And they could decide that case 1 is, for Baldoni and case 2 is also for Baldoni. It's possible.
Yes.
This was, talking about the instructions, but this is a thought here. As evidence stands, they won't make it to number 4 on that list. And I mean, hey, when you guys are walking through that, like now, and I know it's fair to say yesterday it's a 50-50 shot. And I know people will be like, how can you say that? I mean, there are people on the other side. I think I could speak for everyone in this room. We're kind of leaning towards Baldoni, but it's like there are people on the other side, and you don't know the judge and the jury. It's like that's why it's safe to call it 50-50. You never know how these people will react to some of this stuff. But
well, and it's nice to look at that list, and then you can look at it and say, I don't think that they have a strong case getting past number 4. That's the beauty of looking at the jury instructions, is that it builds your case for you.
And exactly. By the way, so running through that exercise, maybe was
beneficial.
And all the lawyers in this case know these jury instructions backwards and forwards, so they know what they're trying to do in the case. But look at what the judge is going to tell the jury as he gets to this jury instruction 2524. It's where severe and pervasive is explained, and the judge just literally reads this to the jury. Okay, there's no examples given. It just he or she just says severe or pervasive means conduct that alters the conditions of employment and creates a work environment that is hostile, intimidating, offensive, oppressive, or abusive. In determining whether the conduct was severe or pervasive, you should consider all the circumstances, including any and all of the following: the nature of the conduct, how often and over what period of time the conduct occurred, the circumstances under which the conduct occurred, whether the conduct was physically threatening or humiliating. And the last one there is that if there's only a single incident, and that's only included if there's a single incident. And you get this where, for example, if a boss comes and, grabs a woman in an area that he shouldn't grab her, and, and just that single
severe action,
that single incident alone is enough to rise to the level of severe and pervasive conduct, because it's just so over the top.
Right.
But if a boss comes out and gives his secretary a shoulder rub, that's inappropriate, but that's one time. And is that enough to rise to the level of severe and pervasive? But what if he gives her a shoulder rub every day for 2 months and she's clearly uncomfortable with it? She's afraid if she says anything, she's going to lose her job. Well, now we're getting into what's the nature of the conduct. Well, you shouldn't be, touching your secretary's shoulders for any reason whatsoever.
And that would alter the condition of employment to make it more hostile or intimidating, offensive. Right. So, I mean, that if somebody is doing it consistently every day, then it does alter, versus if it's a one-time thing, but it never happens again.
Right.
That didn't really alter the work.
And of course, Baldoni's attorneys and Lively's attorneys are going to have this blown up because they know this is one of the Achilles heels of the case. Severe and pervasive. It confuses the jury, and so they're going to blow this up. And in closing, if the judge allows them, they're going to blow it up in closing, and they're going to point out to, hey, let's take the nature of the conduct. Let's talk about that. What did the evidence show in this case? Did you guys see Justin Baldoni? What did he do? We've talked to 5 people that were on the set. They came in and said, hey, no, there was no issues. And so you're going to see people go through that. And then you're going to have Blake Lively's attorney standing up saying, hey, she came and she had these 17 points and they signed off on them. And so you're going to see both sides trying to convince the jury that they fall into these categories.
Yeah.
And that way, when the jury's back in the jury room looking at these categories, hopefully they remember and hopefully they have taken good notes and they go, yeah, I can do severe and pervasive. That's, and then of course the substantial factor, that's the other area where people are going to spend a lot, the defense and the plaintiffs are going to spend a lot of time trying to win on, because if you get the jury to say, gosh, this just isn't a substantial factor, when again, nobody really knows what that means.
And I guess this is where you get into the point of people being a little outraged over the idea that, Lively said that she was in that birthing scene and, she said it wasn't a closed set and she had very little on. And then Baldoni's side saying, no, that's not true. It was a closed set. And she actually had, a number of garments on underneath her. And she was with a professionally trained actor. So I think that's where you get into this kind of idea of severe and pervasive. So what's the nature of the conduct? How often did it occur? What were the circumstances on which it occurred? That's something that's kind of hit me multiple times here, is that this is a movie with 2 actors where they're pretending to be in love. The nature of that work is very different from working in an accounting firm where you're not supposed to pretend to be in love, with the boss, or the boss isn't supposed to pretend to be in love with you. That's not the nature of the work. And so I think just putting it in context is very important for the jury to decide these issues.
And you're talking about the actual facts of the case, and we'll get to that question in 1 second, Eric. You're actually talking about the actual facts of the case, like they're true, and they're we're just arguing over interpretation of what happened.
Yeah.
What about the lack of credibility that perhaps Blake Lively is going to have, where she says something happened at a dance scene, and then of course the audio shows that is not that's not an accurate rendition of what happened. And if you remember, you and I had raised this probably 4 months ago. It must have been January, where we said there's a jury instruction that says that if a jury believes that somebody's lying to them or not being fully forthright, that you can discount everything they say, and not just the thing that you think they're not being forthright.
Their whole testimony
can be discounted. And if I was Baldoni's attorneys, I would really try hard in the depositions, which you say can't go forward, and I agree with you. I would really try hard to lock her into as many misstatements as possible. Other people would say these are outright lies. And then you get her on the stand in front of the jury and you show that lack of credibility. And then in closing, you bring it together and you say, look, you've heard from Justin Baldoni. You've heard from people that don't have a dog in the hunt, that were on the set. They're here just voluntarily testifying. In fact, they're scared to testify because they're afraid that they're going to be tarred and feathered for doing this. But yet they still showed up and they're testifying about this. And then you've got Blake Lively. And let me show you where she wasn't credible. Here, 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 and here. And by the way, remember when the judge told you that if you don't believe somebody's being credible with him, you can throw their whole testimony out. I mean, wow, you could really put together a nice case here.
Yeah. And again, that goes back to the jury instructions. And if you understand the jury instructions, now you can build your case. And so, yeah, that's going to be very interesting to see how that plays out in deposition.
Yeah. I mean, I think what you said about it being a movie set and like you have to think about that a little bit closer is a good point. And it's like this has been going on for 6-7 months now. We saw the Big Times article and it's like, oh, wow, these things happen on movie sets. People do get, harassed and things like that. And you kind of take Lively's side at first and then it comes out, you see the audio and video and it's like, wow, it doesn't really seem like there's really any claims. And this was another comment from Serendipity says, I cannot imagine a reasonable person thinking that showing a birthing scene or saying that the spray tan smells good can cause severe and pervasive damage. So, I mean, yeah, it's probably right. I think a lot of people will agree.
So Serendipity, good comment. So in these sexual harassment cases, generally what happens is it's the totality of circumstances, especially when it's not some big isolated instance that caused it. The boss coming in and grabbing a woman inappropriately and by her breasts or somewhere else. That's severe and pervasive. But most sexual harassment claims that are valid are just a totality of circumstances. It's over a period of months. And the discomfort starts out as, the boss being very nice. And then the boss feels rejected at some point, and then it goes downhill. And Keith, you and I, in several sexual harassment cases we've had in the past, we've been surprised by the age of the mediator that we use.
Yeah.
What happened? Well, there was one case in particular where we used like a 75-year-old mediator, and it was a sexual harassment claim, and it was a very good claim. We ended up getting good result for the clients, but we were at mediation. What did that mediator tell us about our claim?
We represent a woman who had been sexually harassed, and this old guy mediator pulls us out of the room, says, I just want to talk to the attorneys. And he goes, I just don't really even understand these claims, because in my day, women went to work in order to find a husband. So I don't see what the big deal is. And that's when we were like, oh boy,
Oh my gosh.
somebody missed a software update, because that's not what's happening now. And, then you're thinking, well, yeah, I don't know that we're going to get a fair shake with this mediator. Now, mediation settlement's voluntary. So if you don't settle, you walk out. But, oh boy,
But we were unable to settle that case. And we settled it, right as we were picking the jury. But we were unable to settle that case. But we were young lawyers back then, and I don't think we fully, mediators don't have teeth.
No.
But now we pick mediators that we know have a track record, and
well, with
and a
this
software
particular
update.
case, and a software update. Yeah. Let me talk to you about your views on how people find spouses, and then I'll decide if I should use you as a mediator. I do want to say one thing though about that comment by Serendipity, is that does go to the credibility of the attorneys. And so, Serendipity is saying, well, I can't see how a reasonable person would think somebody saying a smell tan smells a certain way would be severe or pervasive. Well, this is the issue, right? So when you're an attorney, if you're going in front of a jury and you're saying, oh my gosh, my client has suffered severe and pervasive harm, and let me show you, because this guy said something about her spray tan.
Yeah.
The jury's not going to buy it.
Right.
I mean, these are reasonable people that are looking at it. So that means you're going to have to bring something together that's better evidence.
I thought you were going somewhere else with that, and I'll say it, and that's why you don't make a big hype about everything.
Right.
That's why you don't scream, oh my God, can you believe that he smelled her spray tan? Because the jury's going to go, what?
What's the big deal?
What's the big deal? So that's why you use your fireworks for where you need them, and not
Right.
everything is a level 10 alert, and then nothing. It's a nothing burger after that.
Yeah, because the people on the jury are going to be sitting there evaluating this, and they are going to use their common sense. And to them, they're going to say, what's the big deal? Especially, for a very famous actor who's making tons of money to be on a movie set, and somebody said something about a spray tan. Because if I was sitting on the jury, I'd be like, do you know what I have to put up with in my job? It's much worse than that.
Keith, I just want to point this out. This is kind of an aside, but I thought it was interesting. And the jury instructions, they have case law that's been reviewed by everybody and included in the jury instruction. And you can read this case law. It helps you understand how the jury instruction became what it is.
I see.
But there's 2 points I want to make here. One is that that here there's a 1994 Supreme Court case from the U.S. Supreme Court, and it's clarified that conduct need not seriously affect an employee's psychological well-being to be actionable as abusive work environment harassment, which is a hostile work environment. So long as the environment reasonably would be perceived and is perceived, there's that objective, subjective test, as hostile or abusive, there is no need for it to also be psychologically injurious. So you're going to hear Blake Lively's attorney say, the reason we don't have to give her medical records, and the reason we don't have to, and the reason we're still allowed to talk about her psychological feelings about what happened and being down about it, and is this very reason right here. But something else that popped out at me here, we're not allowed to ask a jury anymore to use their common sense. It's a new motion in limine that's filed by the defense. They don't like us to ask the jury, hey, we just want you to use your common sense in making this decision.
Although they are, but okay.
Yeah. And so what's interesting here is that this jury instruction actually says that in order to evaluate whether jurors will use their common sense to evaluate whether a reasonable person in plaintiff's position would find the conduct severely hostile or abusive. The only reason I pointed that out is because we're not allowed to say that to a jury anymore, and it's in the jury instruction as part of the notes. So that's just interesting to me. Yeah.
It is interesting, though, that you don't need to have psychologically injurious conduct or result, but I still think it's the better evidence. So if you're not allowed to bring in medical records or mental records, I mean, it's the better evidence versus having Blake Lively testify, I was harmed.
Right.
And, I felt bad about it. It's just not as persuasive.
Here's a comment. I won't put it up, but I think like the frustration a lot of times is people who are sexual assault survivors feel really like insulted by this. And who knows, that could be, well, they probably wouldn't be on a jury then. They'd probably be marked off. But what about this? Do you think humiliating will be, she has to spin this somehow. Like, will that be the angle that Lively could take or something? And thanks for this question, Amy Kemp.
Interesting.
What do you think?
Would you find it humiliating?
I'm not sure what she had to go through.
Yeah.
I mean, she certainly, I don't know if she would use those words, Amy. She might. Right now there's 3 categories of damages, essentially with a sexual harassment claim. One is going to be the emotional turmoil, whether it's garden variety, which you're not going to have to show your medical records for, apparently, or it's going to be the type of emotional distress that's just off the charts where you have to be treated and so forth. Then you've got the loss of future income and past income, which that could be significant here if Blake Lively's attorneys could convince the jury that she's been harmed because she came forward. She's a whistleblower, essentially, came forward and she fell on her sword. And because of that, she's been damaged and no one will hire her again. And she was an A-list celebrity commanding, $5 to $10 million a movie. Therefore, she should be paid, $100 million for her lifetime earnings or something along those lines. That's an argument you could make. And then the third category of damages, which I don't think she would get in this case, would be punitive damages. So those are the 3 elements or 3 remedies that she can go after from a damages standpoint. But it still leads me back to Judge Lyman's ruling and his order when he says, I'm not going to allow her to talk about any emotional distress issues.
Yeah.
And so does that preclude her from talking about emotional distress with sexual harassment?
Could be. I mean, that's going to be the big question. And I think in terms of humiliating, because the jury instruction was saying that it has to be conduct that's either oppressive, abusive, humiliating. It could be that they angle more towards, well, this might have not been oppressive or abusive, but it's certainly, I felt humiliated. And I think a woman in my position would feel humiliated.
Right.
I mean, maybe it would, again, this is why it's so important to look at the jury instructions so you know which way to go.
Yep.
This was something I've seen some rumblings on online. Have you guys seen anything about this? What are your thoughts about the amicus for Lively from Children USA? So I think there's some donation involved.
Yeah, neither one of us have read it yet. I know it came in, I think, yesterday or the day before. So we will take a look at it. But there appears, I don't know this for certain, Keith, but there appears to be that there was a $10,000 donation made by one of the firms involved with Lively to this entity. Again, if that's true, I'd like to know, was this disclosed in the footnote, where you're saying, hey, we're independent. We're here to help the judge understand this. And we have no affiliation with any of the parties in this case under any circumstances. And that didn't happen with the entity filing of the previous amicus brief. So why don't we take a look at that amicus and then we can opine on it further.
Yeah, I actually have the footnote right here.
Okay, what does the footnote say?
So, because I did pull it up, I haven't really read it yet, but it says amicus state that no counsel for any party authored this brief in whole or in part, and no entity or person aside from amicus curiae, its members, or its counsel made any monetary contribution intended to fund the preparation or submission of this brief. And I think that's where there's a little bit of a hole in the disclosures, in the sense that you have to disclose if somebody paid money to submit the brief, but there wasn't anything in the rule that says you have to disclose that somebody made a contribution to your organization.
Right.
Which,
yeah. And me personally, I would disclose that because
Yes.
that goes to your independence. It goes to bias. And so why not disclose it? And rather than have all of the fine internet people out there that are watching everything that's done in this case, they're going to find it and they're going to produce it. And then it's going to make you look silly. So just don't do it.
Yep. And here's a comment, Ezra Hudson on the board for the other group. Yes, we did a video about that. I'm losing track of the days now. That was 2 days ago, I think. Or just yesterday. So. But yeah, you can check out that video. And thanks. That was Eliza Little who brought up that amicus brief. So thank you. And thanks for the donation. At the end of June, we'll have to do our quarterly charity donation wrap up and present that to the people.
Yeah, that'd be awesome.
Yeah. Random question from Sarah. She says, how is the jury foreperson chosen? In any case, not just this one.
So that's really up to the jury, and it's I'm sure it's done in all different ways, and it also has to do with personalities. I mean, what if you have 11 mild-mannered individuals and you have one person that's just a control freak? Chances are they're going to end up being the foreperson, right?
Yeah.
And then in other cases, people say, let's vote. Let's go around the table and vote. And it's interesting how that happens. And I'm sure there's some people who would say, I decline. I will not be the foreperson, but I'm happy to sit here on the jury. So I don't think there's any, the judges give instructions to jurors that you're going to have to pick a foreperson, and you can do that in any manner you think is reasonable. Let's say that there's two people and they're fighting, and the jury can't kick off to deliberate because two people are both vying to be foreperson. The jury can actually send a note to the judge. Judges don't like this. And they say, hey, we can't get anywhere because, two people are insisting on being foreperson,
right?
Or a juror is insisting on talking about things that you told us not to talk about. That's the one that comes up time and time again. And the judge generally just sends a note back
and instructs them,
don't do that.
Yeah,
or pick a person. Somebody
right.
pick a person. But that's a good question. And anybody that's sat on a jury, it's just a really interesting experience. And Eric, I hope you do get jury. I selected to go to jury selection, and I hope you get selected.
Yeah.
It's a really good experience.
Okay. I trust you.
Keith and I get kicked off every single time because we're lawyers.
Mm-hmm.
So people don't want a lawyer on the jury because we're too strong, I guess.
Yeah, I think so. And that's why people have issues with some takes sometimes. I know this is an off topic, but can you please ask Stuart and Keith what they think of her claims of being sent a secret weight loss doctor? I don't know much about that.
Is this where Justin Baldoni was going to pick her up and he has a bad back, and he basically said that he wanted to have her meet with somebody? Is that the one?
It was that, and then also she was having some issue. I can't remember what the issue was, and Baldoni suggested that she reach out to somebody who was like some sort of a physical therapist of some type.
Yeah.
Trying to help her, but it turned out that this person was also a weight loss specialist.
Right.
But they did more than just one thing, and so then Lively got mad because her perception is, oh, you're trying to send me to a weight loss specialist.
Yeah.
But that's not what Baldoni was doing. He was trying to send her to for some, I can't remember what it was. If it was a bad back or sore knee or something. It's been a while since I've looked at that.
Yeah.
Well, here's some input. When I was a juror, someone nominated another, and we all agreed with her suggestion as a group.
Yeah, that happens.
Yeah,
a
that's
lot.
typically how it happens. I'll bet. Thank you, Phantom.
Appreciate that.
Well, cool. You guys got anything else? Here's just some nice comments. I love what I'm learning about the U.S. judicial system.
Thank you, Amy.
Watching you both from the UK. Here was someone in Norway.
11 p.m. Wow.
Italy. New Zealand, Scotland. It's pretty crazy here.
Nice.
Fantastic.
But yeah, people were excited for 3 days in a row of A2L. So thanks everyone for joining us.
We've enjoyed the last 3 days.
Yeah,
and
it's been good.
I've stayed busy and I've really appreciated it. And we've had some fun talking and debating about the case.
Yeah, it's not always easy to squeeze in our live, but we really love doing it. And I'm glad that we can bring hopefully some education and perspective to all this.
Yep. Well, thank you again to the jury pool, and thank you for all the kind comments that you make, and also the insightful comments that you make that led us to today's show, where we wanted to take a deeper dive into the jury instructions and also to hone in on these damages, because emotional damages may be out.
Yeah, who knows? I mean, we looked at our comments and we did some critical thinking. We followed our own advice.
Yes. Good. So we'll see you guys next time. Thanks for hanging out with us.
Have a great day.
We don't just talk about the law, we practice it. At Albertson & Davidson LLP, we're dedicated trust and probate litigation attorneys fighting for abused trust and will beneficiaries.
If you're facing a trust or estate dispute, visit aldablaw.com to see how we can help. And don't forget to join our jury pool by liking and subscribing. See you next time.